wait. Okay, perfect. So just, of course, since we have everybody here, we'll want to do a formal roll call to establish that we do have a quorum. And so if it's all right with everybody, I'll just go through, since we have a smaller group, kind of who shows up on my screen here. So Dewan Tatum.
Here.
Josh Esme.
Here.
Gina Evans.
Here.
Roy Kammer.
Here.
Did I say it right?
Yep, just like a hammer, but cammer.
Okay, perfect. And then
So
Allie-
Madam Chair,
Yeah.
So Madam Chair, sorry, I should make introductions. Allie is with the Senate legal nonpartisan legal staff, so she'll be sitting in on these on some of these meetings anyway, and will be available to provide legal support for the task force. And I should also note that since you're here, it looks like a quorum is present.
Perfect, thank you. And of course, as it says, I'm Lucas Dawson. So one of the first things that we do need to do today is we've now formed these subcommittees, and we do need to create a subcommittee chair. That's one of the points, so that we can, of course, have a way to move through this process. So I guess, are there any nominations?
I would like to nominate you.
Okay. Any others? I'm willing to take that on, but
That's the primary qualification. I'll second.
all right. I suppose we can just go through, though, take a short vote here. See if
Madam Chair, if you'd like, I could handle that role for you.
perfect. Thank you.
Oh, absolutely. And I suppose for the purposes of the quorum, is Ms. Williamson here?
No.
She is not here. I will note that. This is for the purposes of that recording, basically, just in case, a member of the public is watching this. They can't necessarily see the member list. Anyway, thank you, Madam Chair. So regarding the motion by Ms. Evans to appoint you as chair, Ms. Dawson, how do you vote, Ms. Dawson?
I guess in favor.
Yes.
If I can,
Fair.
I don't know.
Yep. Sorry. That came off as a little, what are you doing? Mr. Esme.
In favor.
Ms. Evans.
In favor.
Mr. Tatum.
In favor.
Mr. Kammer.
I am in favor, but I'm not officially appointed to the subcommittee, so I don't know that I can vote.
That's fair. Madam Presiding Officer, soon to be chair, I don't know how you want to handle this, but yeah, I suppose I simply won't be calling Mr. Kammer's name for the duration of this meeting. And Ms. Williamson. All right. Well, in that case, the votes are 4 official members for, none against, so the motion carries. Congratulations, Madam Chair.
Thank you. Okay, so the next topic, and I hope you all have kind of realized I'm definitely one of get to the topics and keep moving on. So one thing that we do need to talk about is, of course, future meeting topics, what it is that we want to address. I know for this particular subcommittee, we had discussed at a previous, I think, couple meetings, sort of some topics. And I think it would be helpful to have some topics identified, as well as, so not only topics that we'll want to make sure that we're addressing and of course open to feedback, but also of course how often we will want to meet and make sure that we are being productive with our time. So with that, I think, and I'm wondering if it would make sense for people to kind of give some input. Let's first start with future meeting topics. Why don't we kind of take it piece by piece? What are some people's thoughts on that?
Permanent list.
And you're talking.
I'd just like to look at permanency. I mean, I think it falls within sort of our bucket to look at permanency from the perspective of should there be a remedy available for so both the list, like which offenses are on it, although that might be a little bit more to the other subcommittee, but then definitely the bar to any remedy for permanent disqualifications. I'll just lay my cards on the table. I think that should be completely gone. It makes no sense.
And I think that that would definitely be interesting to get some feedback on. And I guess I also look at that if I'm going to be sharing some of my probably personal views on that too, especially when I'm looking at somebody who committed an offense as a juvenile, which I understand the juveniles, I think were partially considered in the disqualifying crime, but I do think it carries over to both. So, especially when we're looking at that. So,
Or should they be bars, right? Like they're barred from getting a set aside for a period of time and then they can be considered, right? That would be the remedy, that it's not a permanent disqualification. It's a bar from being considered or some kind of remedy for those.
right.
Yeah.
So I think
Because forever is a really long time for people.
right. Well, and I think just so I'm understanding your kind of thought process and what you're throwing out there is that we're not really necessarily looking at a permanent bar, but that somebody with whatever sort of a qualifying offense would still have the option of either a set aside or a variance. Is that kind of, I just want to make sure I'm understanding what you're saying.
Yeah, well, at some point, like right now, the people that are on that permanent list have no remedy. Like it's forever. And like, if that doesn't give someone no hope and lead back to recidivism, what does? Right?
I think that the folks from DHS at the last presentation, I think they used the framework of that, of there being a bar to the set aside. So it was like, there was a disqualification, the duration of the disqualification was permanent. And then separate to that, there's a bar to any remedy for people in the permanency bucket. So I think maybe looking at for sure the bar, I think is within, within our jurisdiction, because that's sort of the absence of a remedy. Whether there should be permanent disqualifications on the front end, I think we could look at, but maybe better suited to the other subcommittee. But the other subcommittee's got so much that maybe that's something we'd want to take on.
Yeah. So you're talking about whether we just have the disqualification on the front end and then they have to go through the actual set aside process, because in my experience, I mean, that can take some time. And so, my clients can be sitting for months without a job while you're just waiting.
Right. Well, okay, well, I think that's the second, another topic issue to look at, which is the, I don't know, the efficiency of the process, or the maybe sort of the user friendliness of the process from the point of view of the job applicant. And I think the delay is a big part of why it's not user friendly.
Well, and I think that was one of, that was, I forget who it was, but somebody that was a big concern also was the length of time to request the reconsideration, whether it's really, there's any sort of ease to it, if it's very understandable. And of course, that then also the length of time that it can take. So that's, I think, has been discussed before.
Yeah.
And I think, I think that that's one thing that I think is hard and isn't always understood, is that length of reconsideration process. In fact, there was just a decision yesterday from the Court of Appeals on maltreatments, which I understand are not necessarily what we're here for today, but it's a similar concept where if it's not done in the appropriate amount of time, you're done.
That's it. You have 30 days. You have 30 days to get all of that information to them. Or, we've had it where we've been able to like call in certain circumstances, and they'll give them like a week buffer or whatever to get it in. But if you don't get it in within, it says in the letter, 30 days from the date of the letter, and sometimes it can even be 14, depending on, you have 30 days within the date of the letter, and then otherwise you've like forfeited your opportunity for a set aside. And then I don't know what the appeal process is, but then there's another time frame. If you're not given your set aside, you have a limited amount of time to then file for an appeal as well. And then you look at that in comparison to the amount of time DHS is allowed to take to get you an answer back. And like, where's that equity in that? Right.
Right.
Like,
Well, and I think it also depends on what you're exactly, like where you are in the process, if you're someone who's entitled to a hearing, or if it's the type where you have to give them all of your documentation. I mean, most of my clients don't have, for example, if they've completed some sort of therapy, they don't just have those letters lying around to be able to submit them. They don't have their treatment records just at the tip of their fingers. It takes a while to actually get them from other people. And if you don't have them,
Or transportation. That was my situation. No transportation, fresh out of treatment. And I had stuff in 8 counties. I had to go get police reports from Scott County, Goodhue County. Like it was, and I had 30 days to get all that stuff.
Yeah.
And then some of it was so old that they didn't have it. And I had to email back and forth and get proper verification that they didn't have the records because they were so old, and then make and verify. Like, so it's a lot. I think the other thing too, is like, oh, I lost my train of thought. I'll remember.
Well, I'll just jump in real quick. Thinking about how to frame this issue sort of for our topics, we might look at it. I know I had, when I was sort of speaking earlier, said like user friendliness. But if you think about it, the whole goal of this remedy process is to allow, let's call them qualified people, right? So like they're people who are disqualified, but are qualified because it's safe for them to work. Or we could call them safe people, I don't know. But this person who is going to pass through the remedy process and be allowed to work, the whole goal of this process is essentially to allow that person to get a job, right? And so we might look at it from the perspective of, is this remedy system effective in letting those qualified people work? And that delay that it takes DHS to pass them, I think if we look into it, at least anecdotally from my client's perspective, costs them jobs. So.
Yep. The other thing is too, like, I think looking at, so for us in the chemical dependency world, in the substance use disorder world, like a lot of the clients that we're having to wait 5, 6, 8 months to get the go ahead to allow to work, they're 1 year to 2 years free from chemicals. Their crimes are chemical related, and there's no special dispensation for that. They're treated the same as somebody who, committed some other kind of heinous crime, unrelated to and those are the people that are best served to work with our clients, right? And so the fact that there isn't, and we tried a couple years ago to get like people with drug crimes that have a certain amount of clean time made it through that process more quickly. If it was just drug related and it had been a certain amount of time from the crime, that they got passed through more quickly, but it didn't work like it would. And then the other part is there's supposed to be this traveling set aside, and they talked about that at that hearing or whatever, but it doesn't work. Like, here's an example of why that's not working. So we just moved buildings. So all of our women moved from one address to another address, and all of the program staff had to get run through background checks again to get over to the other building.
And it was full process, like nothing was automatic. Yeah, I was interested when they were saying that was up and working, because it doesn't actually seem like it that much from the perspective of the field.
We're not seeing it.
So maybe should we look at traveling set-asides as their own issue?
Sure.
I mean, I think it kind of falls under the umbrella of like, is this efficiently letting people work? But
well, and I think especially right now with just what we call the worker short. I mean, everywhere you go, there's not enough staff. There's not enough staff for, after school programs for children, childcare settings. I mean, all of them, where that has trickle down effects for other things. So it seems there's got to be something more efficient.
Yeah.
Go ahead.
Yeah, I just wanted to piggyback off what Gina was saying. Like I also went through the process of the background study for a crime and been disqualified permanently. But was once I had got a set aside. And they changed the laws years, maybe like 5 years later. And it comes to the point now that I'm not, now I'm not qualified. I don't qualify anymore just because they changed a certain statute of, over time or whatever happened, but nothing happened with me. Change process continued, been in recovery 5.5 years. But since they changed laws, now I'm affected from that. I'm a victim of that, should I say, from something when I was 19, I'm 45 now, so, and it kind of, but I'm still in the field, went through the process with getting letters, like the waiting process, the 30-day, you better hurry up and get this in. What is this paperwork in front of me? I still got the paperwork now, but yeah, they permanently disqualified me, told me I could take it to the appellate court. I was working with a lot of different organizations in the community, and which I still do. Letters. I work with judges, letters from multiple judges, prosecutors, probation officers, and still got, disqualified, and I was seriously surprised behind that. I continue to, I work for different organizations still now, but at the same time, I can't work with individuals in a treatment setting, and I should have my LADCs, but I can't take my tests now. I already finished the schooling and, got to the end, and, you get it. It's like, like haven't killed anyone, no one killed anyone, taken advantage of, and, crime is a crime, not minimizing criminal activity or anything like that. But I'm not the same person I was when I was 20 years old and 25, it just doesn't add up. Can't even remember, a lot of stuff back then, yeah. But there has to be some kind of remedy for, like, I would think, pay attention to, like, individuals, take a closer look, like we're having conversations right now, DHS to be able to sit down and talk with individuals. And just like the senator said in the beginning of our meetings, he mentioned about, like, he doesn't see, the actual ripple effect behind signing these bills, and it makes him think about it. So I was really glad about it. That really made me happy, though, to be able to, so they could actually see it, and actually give us a chance to take a look at that, and he opened the door for that. Like far as that, being able to sit down and, individually, so I would think that would be like it might come up a little different, but like somewhere in that area, though, as far as like remedies, though, like individuals being able to take a look at what's considered as permanently disqualified. I understand, you got to pay attention. You never know, I understand that. But I think it should be more like individualized some kind of way, to be able to considerations.
Duan, can I just ask a quick follow-up question? Did I hear you say that at one time in the past you were able to get a set aside, but then the statute changed and
Yes.
even though you had been cleared to work before, you were suddenly barred retroactively?
Yes, I was able to work up under supervision. I got the letter that said you have to practice under supervision. So I had to do my internship under supervision, and I was okay with that, so that's why I continued to finish my schooling. And now I took another one. I took off school, wasn't ready to make that full commitment to counseling and change. And so I took a couple years off and came back and was ready to finish it up, and I was ready now. So, and I came back, I had to take another set aside. I'm like, oh yeah, everything's fine, I'm good. Hey, they said I'm good with that, so I should be good. So went in there, boop, permanently disqualified. I was super surprised. Yeah, Baylor down at MCTC, Minneapolis Community Technical College, Doc. He knows about it, like they encouraged me to finish the schooling, so yeah, like maybe I would say like 5 in between, like 4 to 5 years in between of a change of the set asides. Yeah.
So there was a statutory change that bar to set asides for permanent disqualifications is relatively new. So yeah, I think we definitely need to look at that.
Yeah, see, I don't know a lot of like language and like far as what, like you say, the code now. I know my code, the 245, you know, I know, but as far as what like a language, I hired a lawyer to do my paperwork and got it done and stuff like that. I'm like, yeah, there's no way I'm gonna be able to get, like you said, Gina, get here, there, and be able to, at the time, and then still keep the motivation to keep pushing on, because that is a killer right there to take that one. And still but I continue to push. And, I work for, I work for Ramsey County Treatment Courts, Justice Point, trainer down at Twin City Recovery Project. So I continue, I still, I got hope. It's going to work out for me, regardless of wherever it might come out at, it's going to work out for me though. Things have been working, so I'm grateful.
I appreciate you mentioning internship and such. And this is very probably alcohol drug counselor specific to some degree, but even within the different training institutions, there's a wide variety of how the background check is treated. It sounds like you're at a program that was very proactive in getting it done early and being supportive. There's other academic programs that use it as a screening tool to screen people out of programs. So in talking earlier about, that 30-day window of getting things all pulled together, there are programs in the state that prepare students and tell them that this is likely what you'll need to do. This is what you likely need to start working on, pulling together and thinking about, and really preparing students. And there's others that just say, we're not going to deal with it. So it's probably not the purview of this committee, but I think it's important information because we've got some people really out there helping and others not. And it's limiting workforce in that regard, because some just say, can't go here, it can't pass the background check, can't get you into internship, not willing to help you, and end of story. So so I just appreciate you sharing that you were at one of those programs that appeared to be very helpful and supportive.
Yeah, in the beginning, like you stated, you take the test in the beginning. You gotta, you take the screening in the beginning, the FBI and all that before you start your school, so I took it, you gotta take it right away. So that was the reason. And then I come back later to finish. Now I'm not, I'm disqualified. Yeah. But I still finished my schooling. I still got my degree. Yeah. I had to take a liberal arts. I just took it just to take the degree, just to finish it up. Yeah.
I think what's like some conundrum for alcohol and drug counselors in particular is I get there's background studies and background checks, but when you think about licensing, people can still get licensed to practice alcohol and drug counseling based on their conduct and crime and so forth, because the licensing board uses a very different process than DHS uses. And this is one of the situations we hear consistently in our field, that I can get licensed and but yet I can't go practice in a licensed facility because there's two different processes. And I don't know how far that translates into other professions as well, but
it's a lot like that.
Okay.
Nursing is the same.
Yeah.
Even the like smaller like licensing things, like like your CNA and stuff like that, like you can get that and you're entirely separate from whether you can pass the background check.
Yeah.
Can I move forward with some other suggestions?
Yeah.
I think looking at the preponderance of the evidence standard, I think that fits well on our side of it, since that mostly comes up as part of the remedy process. So a couple questions on that. Is that even the standard that we want, given that it's used to disqualify people who have not been convicted of crimes, and that's exclusively what it is used for. And then I'd also like, and maybe we can get someone from DHS to come through. I'd love to hear more from their perspective on how exactly they use their discretion in making that initial preponderance of the evidence determination. To me, it's always seemed like preponderance of the evidence is close enough to reasonable doubt that, basically any police report that is written to justify the arrest of someone is going to be something that, I could see a reviewing attorney look at and be like, well, that's preponderance of the evidence too. So how much does this just pass the discretion on who gets disqualified, all the way up to the officer and how he writes that report. I'd love to look at that.
Well, and I think that that's important because I think, probable cause is sort of just theoretically, I think, below preponderance of the evidence, but they are so close and they are technically different standards. But yeah, you read a police report, and if you talk to any police officer, they're going to tell you, well, based on my investigation, it met the elements of the crime. However, they're not the actual finders of guilt. And they'll also tell you that. And so, but their police reports are then reviewed and used to make this preponderance of the evidence determination, where especially in kind of the example I often look at are like domestics. You look at domestics, and that's often, don't get me wrong, they're very important, they're very serious, they're all of that, but there's also just a unique and slightly different element to them. And, you look at the police report, especially when emotions are high, and just using that police report doesn't give you the full information. And I think even especially when, I think you can look at a police report. I mean, I recently had an officer testify in a case that it was a crim sex, but that it met the elements, because somebody technically said something, but charges were never issued. And in fact, charges were declined sort of very strongly. And so you've got, just because it might meet certain elements, that all the officer is looking for is, are there the elements? They're not there to actually make that determination. And so even like, for example, in the crim sex context, again, it's a police report, but they're not the finder of fact. But that's what's being used.
So that's the problem I have with the way that DHS uses these police reports as the only, whether it's preponderance of evidence, whether it's looking at, because that's all, and that's what I tell people when I'm trying to help them with this, right? That's all DHS is using is these police reports to determine, kicked pregnant wife down the stairs or whatever, right? That's all that they're looking at. And I'm gonna just call out the elephant in the room, right? They can be really biased, right? Police reports can be really biased. Like we all have biases, law enforcement included. And they're just writing up what they see in the heat of the moment at a police stop, at a domestic, at a whatever. And that's all DHS is looking at, other than whatever a person is turning in. And like Dewan, when I did my appeal for my permanent set aside, I hired an attorney. And so then you're looking at people with resources are going to do a better job. Like there's so much bias baked into this process, starting from the police's perspective to how much resources or education or ability someone has to be able to fight against only these police reports that DHS has to look at. And how do we make that more equitable? How do we balance out that process? And like, how do we shine some light on that as our jobs? How do we explain that to the legislature, to the community? And how do we do that through a portal? How do we do that through something that isn't so paper? Higher education is going to do a better job. Am I making sense? Because it's so discriminatory the way that it's set up right now, and starting with law enforcement and biases they may or may not have being the one source of information that DHS has to how well somebody can read and write and explain the progress they've made since that time.
Well, and I think sort of piggybacking a little bit on that too, the other concern with the preponderance of the evidence is that somebody can be disqualified up front. Again, kind of what we've talked about, and then there's no income. They're not able to work based on something, somebody either hasn't been charged for or not convicted of. And so I guess, is there another option to look at it potentially of, if there's no conviction, Does the disqualification, should it really kick in right away? Or should it only kick in, especially if we're looking at a somewhat lower standard? Because I understand the hard part, a conviction is your highest standard. We have plenty of standards in the legal system. It's a lesser standard to terminate someone's parental rights, just by way of an example. So I don't know that any of us here are necessarily saying the standard should only be proof beyond a reasonable doubt, but should there be a different process when there hasn't been that conviction, for example, where maybe the disqualification doesn't kick in right away and DHS is perhaps first put to the burden of proving it in a hearing setting before that disqualification can actually be put into place? I don't know, just an idea.
Yeah, so it's like question number one is like, should we stick with the preponderance of the evidence standard? Question number two is then, like, to the extent we do, should those be subject to a little bit more protective process?
Yeah.
I'd say just another sort of corollary issue is right now the way that it's set up is that if you don't challenge the preponderance of the evidence determination the first time DHS determines it, you permanently waive your ability to do that. And I can't tell you how many people like come into my workshops having no idea that they applied for a job, they didn't pass the background check, they needed a job, so they applied somewhere else. And then, 4 years later, now they're going to nursing school and realizing that one PCA job that they applied for, created this huge roadblock.
That forever is a really long time.
What's that?
That forever is a really long time.
Yeah.
And especially forever on a preponderance of the evidence. That's.
Yeah, I don't know. I don't really see the purpose of that provision. Like, just let someone challenge it. Why not let someone challenge it?
Right. Well, and especially because I think so many of my clients are, well, does this matter to me now? And I'm always having to encourage clients, well, it may not matter to you now, but do you know if it's going to matter to you in 5 years, 10 years? Especially if I have a younger client, like you were saying earlier, Mr. Tatum, like you were 20 and now you're thinking about it. So, a 20-year-old doesn't know. Lord, I didn't know what I was going to do when I was 20.
Yeah.
Like it's different.
So
Better guidance.
Oh, no, go ahead, Dwan.
No, I was just saying better guidance. Like if somebody, would have been telling us the conversations we're having now,
Yeah.
Got a little better. Yeah.
So a couple of other things. Tell me, Josh, the kidnapping charge, no conviction, leads to people having to register, and then those are leading now to failure to registers, which is on the permanent list. And so does that here, or would that be in disqualifications? Did I bring that up?
Well, actually, I don't, kidnapping itself is already a permanent disqualification.
It is, yeah, but people aren't even convicted of it. They just get charged with it and then plead guilty to any other felony. And now they have to register as a predatory offender for 10 years. And then if they don't, homelessness is often the reason why, or failed drugs, and then they get a failure to register. And then that's on the permanent, it's on the top. They just tagged it right onto the top of the list. You can tell it was an afterthought because of where it is on the list. And
I would
then
typically put homicide first. I'm just saying.
you think, but it's not. You look at the 245C15 right at the top, failure to register. And so do you think here, or probably disqualifications, huh? Because how, or like, do we add a remedy for that once they've completed, or I don't know, that just drives me crazy because they never, for some of those folks, they've never been convicted of it's either not kidnapping. Forget.
No, it's any offense that
it's not the kidnapping that aggravates me though. It's the false imprisonment with intent to confine, because that's sometimes robbed the drug dealer, moved him from one room to the next. When there's kids involved, I get it. But when it's drug deals gone bad, when it's your girlfriend who you're arguing with and you won't let her out of the car, when it's other stuff, when it's kids, it's one thing. Like I don't want to make less of those situations, but when it's really domestics and drug deals and all of that other stuff, that false imprisonment with intent. So just trying to figure out which group.
Well, just to look at, just to sort of think through kind of how the issue is set up, right? So we've got this provision on the predatory offender registration law that says that if you are charged with anything that requires registration and you're convicted of anything else that arises out of the same course of conduct, even like misdemeanor disorderly conduct or something like that, then you have to register.
Mhm.
And now needing to register has two direct implications for the DHS statute. One is actually, if I'm reading this right, 245 C15 subdivision 1 paragraph F, a child care background study subject shall be disqualified if the individual is registered. So right there, for some studies, right out of the gate, just being convicted of that disorderly conduct that arose out of the same situation as something else triggers a disqualification, at least a limited one. And then the other issue that Gina points out is that if that person then fails to register, which is really easy to do, especially for somebody who's homeless, because the requirements for homeless people to register are really, really onerous. I mean, it's like go in person to the police department every week to say, yes, I am still living in a shelter in Minneapolis. And you miss it once, it's a new felony, and that new felony is listed as a permanent disqualification. So I think if we wanted to look at it, trying to fit a remedy framework on it, it seems like there's some overlap with the preponderance of the evidence determination, right? Because it sort of works similar where somebody's disqualified ultimately for alleged conduct that was never proven elsewhere. So like maybe we could look at like whether or not DHS's decision on that issue should override the sort of automatic registration requirement. And then similarly, for the person who is convicted of violating a predatory offender registration law, so like the failure to register person, that one we might just want to look at from the perspective of like, should that person have a remedy? And I do think the other group could look at it from the perspective of like, should a failure to register even be a disqualifying offense, since it's, a technical violation of, failing to submit paperwork or sign something. So I don't know what folks think about that. I think we could look at it. I think we could kick it to the other side. We could do both.
Well, and I'm wondering if it would make sense, because I can definitely appreciate the importance of it, if maybe it definitely does go into our list. But I think some of the other ones are probably bigger ones and more important ones for our remedy list. So kind of devote some time to it, but maybe not make it one of our priorities. I think it might be helpful to kind of create our list and sort of create our priorities of what we really want to address, and then have some secondary pieces of, yes, we'd like to touch on them, but it's not it's not the main priority, if we will.
Yep. There's just so many people that fall under that and
Right.
are unemployable because of it. And the range for that particular one goes from almost nothing to very serious, that it should be one that they look at on a case-by-case basis.
And I know from our prior kind of lists, there were two more. There was expungements as well as some like administrative accountability. So expungements, I don't remember all the logistics of why that had made it on the list. I don't know.
So yeah, that one's kind of my baby.
Okay, that's it. And I knew somebody would remember.
So there's a couple things on it. So right now, the way that the statute is set up is that notwithstanding an expungement, DHS can still access the expunged information from the courts and the BCA and use it to disqualify someone, unless DHS was included in the expungement petition and the judge included DHS in the expungement order. So it's sort of this, like, DHS gets their own crack at arguing against the expungement, which when they do that creates a weird issue for the courts to decide, because DHS is going to come in there and they're going to argue, look, if they go through our disqualification process, we do all this other stuff that you're not doing here in the expungement hearing. And so you should not expunge it and let us do our thing. That is a problem, though, for a couple of reasons. One is expungement's a better remedy. It's permanent. Like, once you get it expunged, if it's expunged from DHS, you don't even have to worry about it showing up on the next background check. But then two, for a lot of those preponderance of the evidence permanent disqualifications, it's actually the only remedy. Mm-hmm. And you actually see that, quite a bit. And for juveniles, even if it's not a preponderance of the evidence, like a juvenile delinquency adjudication for something that's a permanent offense, expungement's the only remedy.
Yeah, so that's the route I've had to go before. And I know I've seen, once upon a lifetime, I was in the county attorney's office where we would, the expungements would go through. And sometimes when you see DHS coming in objecting to juvenile records.
Yeah. So one thing I would like to look at.
I think it's not for the courts.
Juveniles.
In some respects, I think there's some of that's where it takes the judge too.
Yeah. So the couple of things that I'd really like to look at, just now that groundwork is laid, I'd like to look at what is DHS, similar to like how they do the preponderance of the evidence determination. I'd like to actually have someone from DHS who makes decisions on case-by-case basis explain how their discretion is implemented with respect to whether to object to an expungement or not. And both, how are they doing that now, but then also what discretion is afforded to them, because there could be another administration, that wants to do things completely differently. I'd like to just sort of think about, whether we want it set up that expungement is the primary remedy or the best remedy. And if it is, I don't know that it makes sense to have it set up so that DHS has their own opportunity to fight against it. Like, maybe it should just be if you get an expungement, then that clears you. Because another problem that people run into is if they do an expungement, but they didn't notice DHS, then they're completely confused why they're still getting disqualified over something that they thought was expunged.
And I think that's also where it can be difficult, again, when you're looking at the resources people have and have available to them. Whereas as an attorney, I include it, but I know to, but not everybody does,
No, and the public defenders don't, not because they wouldn't want to. And I know frankly, sorry, I should say lots of public defenders do, because they go above and beyond, but you're not entitled to have an attorney to help you, clear your record afterwards. And then a second thing, a more technical thing specifically related to this, is that there's a provision in the expungement statute, it's 609A.025, that allows for sort of a short form expungement, expedited expungement process, if the prosecutor agrees to the expungement. And this is something that it varies by jurisdiction, how sort of aggressive prosecutors are in agreeing to it. But I think it's something that they're getting used to doing it more. The Attorney General's office has this really awesome program right now where you can ask them to help you with an expungement. And if you qualify, they'll reach out to the prosecutor and try to convince the prosecutor to do this 609 A025 expungement. But it doesn't have a petition. And so it doesn't work. I think this is just a drafting mistake, that it doesn't work with the language in DHS's statute, because DHS says that they need to have a copy of the petition. And so if we go through the 609 A025 expungement process and there's no petition process and it happens automatically, I think there's potentially the possibility for DHS to say, okay, well, we're not honoring this, and we're still going to get the information to disqualify. So I'd like to hear from them how they interpret that conflict. And that may be something that, is even just like a relatively simple, like we just need to tune up this language and make these two statutes work together.
And so I think that then, well, and I think let's finish up. There was that last piece, at least on the initial list. And then Mr. Vogel, I think that would then help me perhaps ask a few questions for just assistance on some of this. So the administrative accountability, I believe, was Ms. Williams kind of, I think that's one that she has voiced, and I understand she's not here, but I don't want to ignore it. But I think, and I don't know if that's something to look at, is it built into the statute, or is there simply something that is available within DHS? And maybe that's something that we would just want to hear from DHS on, if there is a process. I don't know, what are people's thoughts?
Yeah, this isn't an area that I've actually practiced in. I got the sense that what she was thinking about is like what is the remedy for like actual misconduct, like when it's really, when it's really bad, can you sue DHS? I think then we're getting at issues of suing the government and all that. But
we talked about that yesterday during data a little bit. Will, Mr. Vogel, can you remind us what Chris said yesterday, what Mr. Zempel said yesterday?
Certainly, Ms. Evans, and Will is fine, whatever you prefer. Yeah, we did talk about that briefly in the data subcommittee, and Mr. Zempel from DHS, he's their legislative affairs coordinator. They're willing to supply whatever information they're allowed to supply eventually, but they're not allowed to supply very much. This falls under personnel confidentiality issues. This is individual personnel files, and disciplinary records would be private data. Essentially, stepping back, the sense I got, and correct me if I'm wrong in my interpretation, Ms. Evans, but DHS is not really able to provide very much there of the sort that Ms. Williamson wanted.
Yep, that was what he said. The other thing that I just, and if you interpreted this differently, please let me know, but they're swamped, they're understaffed. They weren't able to hire a temporarily funded position for us over there like we were funded for. And so Chris was very, very clear that we need to be prioritizing data we're looking for from them, because even the data we asked for from them originally, which has been weeks and weeks ago now, they're going to get some of it to us this week. And so we need to really be thinking about what data do we need, and be prioritizing data, which is unfortunate. It's going to be really hard to get this work done without the data that we need. So,
well, and so then I guess I'm kind of wondering if it was discussed in the data group, if I guess other members are all right sort of tabling it and allowing it to be addressed in that group, because I do think I don't want to ignore it, but at the same time, if it's potentially already going to be addressed somewhere else, to not be duplicating our efforts. And especially because I think there are there are many topics already that we are, I think more appropriately probably fit into the remedy subsection.
I
So
agree.
is Miss Williams who was bringing up this issue, right?
Miss Williamson, yep.
Or Williamson, yeah.
So Gina, did it sound like she was interested in specifically in like internal disciplinary measures?
She just wanted to see, like, when other people too talked about it. The lady from Minnesota Care Partners also wanted to look at, like, are there individuals, and we don't need to know who, but are there individuals who are no people compared to are there individuals that are yes people, like, and like standardization of, does every person that has this crime under these circumstances hear a yes, or are there people, like, more along the lines of standardization?
Okay, so I'm so glad you clarified that, because I'm really interested in that too. And so a couple times now here I've said, when we're looking at like, how do they make their decisions about set asides? How do they make their decisions about preponderance of the evidence? How do they make their decisions about what expungements to object to or not? All of that stuff goes to that big question of how are they actually applying the very broad amount of discretion that the statute gives them here. And I think we should, that is exactly data that I would love to see. And I also love to sort of have it kind of anecdotally explained, from the perspective of one of their attorneys who are reviewing these documents. But I think we can frame that in a way that doesn't get to, personal, employment records stuff.
Yeah, we talked about that a little bit, and Chris, we gave him this big long list of data that we wanted, and he just said, like, we're understaffed, we're short-staffed. Any of the data that you guys are getting, it's pulling somebody away from actually doing set-asides. And you guys need to decide, like, what data do you actually need? Because we're not going to be able to give it all to you. So what's important, you need to prioritize. So we really need to decide, like, what are the most important pieces of data we need to get this work done. So is that it? Is that the most important data we need to get this work done?
Well, and I think some of that, I think then of course goes to, because I mean, here's sort of a couple thoughts I have. I mean, one, the data group, at least, and I don't know what was discussed and ultimately decided, but I do think
nothing's been decided. We need to get it together and get it over to them. And I guess, sorry to interrupt, but is that the most important data we need first to start this work? Because we have until the end of next year, right, to get a report together, but to get started while they're in this transition, going back to pre-COVID, because they're buried right now, right? They were doing emergency background studies and now just went back the middle of November to 2.0 background studies pulling from other states. And so, right, they're back in the middle of a transition going back to non-emergency. So they're extra buried right now trying to get studies back together. So to give them a little bit of grace, but that they're going to get caught up in the next couple of months and probably be able to give us a little more time and energy. But right now they're just running on empty. So what do we need to get started is the question.
Yeah. And I mean, I think to me, just kind of hearing what it's about, I do think at least, I mean, originally I was kind of thinking, does this go to the data group? But now hearing it clarified, which I think really, really helps, because originally I was under the impression it was more of a, are people being disciplined if they're not following? But no, it's actually much different. So to me, hearing this clarification, I think definitely understanding and getting data on, are there certain ones that are always a yes? Are there certain ones that are always a no? The preponderance of the evidence, how is it actually being applied? Sort of what is explained to people who are actually reviewing this, because it's still an actual person who has to review it. To me, I guess, at least in hearing this, and I'm open to feedback, seems like that would be extremely important for us as we're also deciding what remedies are actually working, what needs to be changed, because that tells us how it's actually used by DHS.
Yeah, I was at the meeting yesterday, and the way we ultimately framed it is asking, what DHS does in terms of an inter-rater reliability process to ensure that there's some consistency from employee to employee, because our concern is whether or not there's distinguishable variances from employee to employee in making these determinations. And we didn't specify it to a particular part of the process, but really holistically, because there's a lot of discretion here. So we want to know how that works.
Okay.
But so I don't know if that answers your question any more about the information you're looking for, but I'm looking at the informal notes from yesterday, and it just says inter-rater reliability. Is there distinguishable variances between different employees within the DHS system? Is kind of how we frame that for what we're looking for from them. So.
And Madam Chair, that's the perfect point for me to jump in. I do want to point out that the data subcommittee worked up an informal document about their priorities. That will be posted online on the task force website for members of the public, but I can send you all a copy if you would like, just to know what the data subcommittee got up to, essentially.
That'd be great.
That'd be great.
One thing we could think about just for the kind of the game plan moving forward for our particular subcommittee is we may be able to at least start understanding the issue better, just by having one of their licensing attorneys come into our next subcommittee meeting and just walk us through. We won't have the metadata, right? That wouldn't give us, Roy, you used a term that I had never heard before that sounded really good. It wouldn't give us that data like that, but it would, from the perspective of that one individual, help us understand maybe what is their, what was their training? What are they told to look for? That kind of thing. And then I think related but slightly different from that, I think one of the things we should also be looking at on all this data stuff is how has it changed? When there's a change in the administration and a new commissioner, one thing that I'm sort of curious about or interested in is how much does the changing personnel change outcomes given how much discretion is baked in there? Because maybe we have an opportunity here to tighten it up that could protect against a much more restrictive regime coming in when circumstances change down the road.
Yeah, I think that makes sense. So kind of just as we've been going, and I don't know how long was this meeting allowed for? I wasn't sure.
Ms. Dawson, that's sort of a strange thing. I scheduled it for an hour, but that was entirely arbitrary. We have the room until 3 p.m. today. So as long as members want to meet, I'm not saying meet till 3, but it's available for however long you want to use it.
Okay. So, so thank you. But I'm sure all of us have many things that we probably need to be doing. So I just want to make sure we're also efficient with our time. So just kind of as we've all been talking, at least some kind of big ones that are jumping out to me, I think a lot of what we're talking about is really what we had established on that original list for this process, looking at the permanency, the efficiency, which to me, the efficiency of the process, I think I kind of bucketed it with the user-friendly, the delay, the length of time, the time to gather documents, as well as the traveling set aside. I think statutory changes, especially addressing Mr. Tatum, what you had gone through, as well as what you just said, Mr. Esme, about the changing personnel, and is there a way to kind of look at that? The preponderance of the evidence, the registration piece specifically, expungements, and then administrative accountability. Again, kind of how we have now clarified it based on today. Is there anything that anyone thinks we're missing?
Sounds pretty good to me.
Okay, so how do we then, I think then kind of moving on, how do we want to try to tackle this? Do we want to sort of just each time, I want to make sure we use our time. So if we're looking at the next time, would we want to plan to discuss maybe 2 of the topics? How do we want to address this? Is it, trying to keep notes so that we're actually keeping notes as to what it is specifically? Are we each doing a little bit of homework ahead of time to make sure, for example, like the permanency list, that we all kind of have that in mind and we're ready to go and can sort of make suggestions? What are people's thoughts? And again, of course, trying to keep in mind that we all have, this isn't our only thing going on in our lives. So what are people's thoughts?
So I have one thought. I would like for to recommend that Will do some research about what other states do for remedies for this issue. I think it would be good to know what other states are doing in this area. Is that something that, I know I keep giving you jobs, Will, but it would just be great to know what other places do.
Madam Chair, Ms. Evans, I could absolutely handle that. And this is a perfect time to let you know that the data subcommittee has given me jobs, basically researching what other states do with whether they use preponderance of evidence standards, whether particular states are essentially regarded as exemplars in this field, that sort of thing. So I can keep you up to date. I can definitely investigate what remedies they use, but I can also keep you up to date with what I'm letting the data subcommittee know about as well.
Yeah, I think that would be definitely great. And I'm wondering if it would be possible to, and well, I don't know what all you have on your plate, but it seems to me that then our next meeting, that would be helpful if we could start off then with some feedback on that, because I think that then that will guide us in sort of the rest of our work as well. If anybody else has any other ideas on that.
Madam Chair, sorry to interrupt. I can absolutely try to have you some research done by the next meeting, depending on when that is. Although I will note with the holidays coming up, that does sort of knock a certain chunk of time out of my work schedule. That being said, this is my full-time job working for the task force, so this is the only thing going on in my professional life anyway. So I will absolutely try to get you whatever I can for that next meeting, whenever that is.
And we're very glad to have you, Will.
Yes. So then I think kind of just my thoughts. So our next full task force meeting is January 14th.
Other way.
I think it would be helpful if, I'm wondering, do we want to try to meet once before then? And would that allow you enough time to have the research? Because that would get us at least through the new year and past that, to actually have some of that information available so that we can have that. And then, of course, start tackling these very important topics.
Mm-hmm. So are we thinking like maybe every 2 weeks to meet for this, maybe for the first little while? Would that be good? And does a running reoccurring meeting work for everybody, or are we going to just pick another meeting date every meeting?
No, I'm wondering if it would make sense to, I do think, again, provided people are available, a meeting, at least initially, maybe every 2 weeks, to really kind of get us going and make sure we're on track, I think would be very good. And I do think it would be helpful to potentially have those scheduled in advance, especially, I understand, I think, as I kind of even said at the beginning of this today, myself, and I don't know about Mr. Esme, but schedules can kind of be all over the place. So sometimes just getting those on are helpful for everybody.
Yeah. So does early work for you all as lawyers? Is that?
Actually, the 11 to 1 time slot works the best for me.
Yes.
I'm more likely to have 8:30 or 9:30 court and 1:30 court.
Okay.
And I would agree with that. Yeah, unless I have a trial, I occasionally have 11 and 11:30 hearings, but for the most part, that's usually a good time.
And
Which
so
I realize is lunch hour, but that's
does that Tuesday the 4th, 2 weeks from today at 11? Does that work for?
So I would need 11:30 that day if people could.
That'd be fine. I've got a 1:30, but
Well, I think, and if we even maybe tried to keep it to an hour, I think that that would still give people time. We're going just a little bit into the lunch hour, but not crazy.
And so we're thinking for that meeting, we'd primarily be looking at what Will can find us on what other states are doing.
Yeah, if Will, you think you can have that by then? If not, we could definitely maybe look at the 11th. So,
A couple big holidays between now and then. Will.
right.
Sorry, Mr. Esme, Madam Chair, I was just emailing Ms. Williamson about that time. With the 4th, I don't know if I can guarantee having a systematic view of all 49 other states, and I guess there's federal territory, but since I want to work through the legislative library staff, and they'll help me. But if you do want to meet at that point, I can absolutely have whatever I've worked up. I mean, for example, if I've gone over what Wisconsin does, I can let you know about that. So it's really a question of, do you want to prioritize a systematic viewpoint or speed?
Well, and I guess my proposal then, because I absolutely want to be respectful and I want you to have enough time. And I guess I'm the type who I'd rather you have the time and we can have that more comprehensive than to, let's say, try to rush you and it's just not. And then we're still asking you for more information. So I'm wondering about Tuesday, January 11th.
That doesn't work for me. I'm at the Behavioral Health Summit for the Council of State Governments for the Justice Reinvestment Act. And so, but I don't need to be here, like, if it's just me. So,
and I'm open to, I mean, I have that week, if it's the week of the 10th, I'm available, for example. I guess the only thing would be is if we were trying to keep it to Tuesdays, otherwise.
Could we do that Monday, the 10th?
I could.
I could.
Lots of nodding.
Yes, I think that one would work. And that day I could do 11. So if we'd like to keep it to 11 and then be done by noon, I think that's definitely possible.
Sounds good.
Okay.
And then we'll have the full committee hearing that week. And then maybe like an idea for our next one might be to invite someone from DHS's licensing team to meet with us and just like ask them to just like go through the nitty gritty, like walk us through like each possible remedy and your decision-making discretion.
Yeah. So, and are you wanting that also for the 10th? So are we trying to?
No, I guess I was thinking maybe we would do that at the second subcommittee. It's just a suggestion. We don't.
Yeah. No, and I think that makes sense. And then, because I'd rather that we have enough time and we're not just trying to rush through and miss stuff. Just while we're looking at it, would Monday the 24th at 11 work for people?
Yes, for me.
Okay, because I'm wondering then, Mr. Vogel, if that's the type of thing, if you could reach out to DHS, especially because again, looking at attorney schedules, if potentially you could have somebody so that we're already organized and it's on the calendar and that person could put it on their calendar.
Certainly, Madam Chair, I'll be sure to do that. And yeah, DHS also has the holiday looming, so the fact that that's later in January would give them more time to prepare as well.
Yeah, I think that should work. So if we can, and maybe if it makes sense for everybody, let's at least get these two on the calendar and then kind of we can look forward from there into February and actually, unless people are looking at their calendar now, I'm actually looking at the 7th and 21st of February actually do work for me. It actually skips right over a few jury trials. So
yeah, Mondays at 11 is actually a really good time for me. I don't know about others, but
I'm wondering, just are there any people see right now anything glaring with February 7th or February 21st?
Mondays are also good for me too. So yeah.
Mondays are generally good for me. I don't know which subcommittee or subcommittees will be on yet, but
you're going to be on whichever subcommittee you pick, Roy.
Okay, good. Okay, well, fair enough.
Or both, if that's what you want to do. So it's up to you. I feel like you bring value to any of them. So
thank you.
The 7th, I've got a jury trial scheduled, but that's going to happen lots of Mondays, and it doesn't necessarily mean I'm unavailable.
Depends on the county and what the offense is as to whether you'll actually go.
Yeah, actually, and I would most likely be available even if it goes, so
Okay.
that should be good.
Are
we could-
Tuesdays better, Josh?
Not really on that issue. I mean, the kind of the way that it is that like lots of weeks end up having trials scheduled, but you know, trials don't always go. And so like you kind of have to plan your schedule assuming that you're gonna be able to be there, and then if a trial happens, it blows everything up. So that's gonna be somewhat of an unavoidable issue for me.
Right. And I know for me, I mean, I think I'm probably like you. It is unavoidable, especially after COVID. So many of these courts are trying to catch up and we're smushing them all in. And so, but if we can at least maybe pencil, put on the 7th and the 21st, and of course, understanding, hopefully at 11, either if I or if you, Josh, do end up having court, if it's the type of thing where we can either get coverage or the judge can allow a recess for us to do stuff or whatever it might be. At least I know, sometimes we can try to do that.
Madam Chair, if those are the dates the members agree to, I can send out preliminary meeting invitations, and if people's schedules change, we need to change that, we can.
That would actually be great.
Yeah, absolutely. I do want to note, Madam Chair, that in February, the task force is meeting on the 11th and the 25th. And I bring that up simply because the task force's preliminary report is due March 1st. I would imagine, administratively speaking, the task force will want to have a completed report to vote on by the 25th. So I suppose I started to say that only the meeting on the 7th would be able to reflect in that report, but a meeting on the 21st, maybe. It depends what you and the task force do on the 11th to agree on the substantive nature of the report. But I just want to remind members that the earlier you make a recommendation to the task force, the more likely it is to end up in that report.
Understood. And I think that that's helpful. And maybe at this point, we'll leave the 21st. And if we need to adjust that, we can. That's
on that issue, I don't think we've really talked in the main group about what that first report is going to look like. But I will probably advocate there, and just sort of what we're thinking here. I think it would make the most sense to use this sort of initial kind of report and the initial couple months of work to do everything we can to identify the problem areas, and then use the rest of the year to work through how we might fix those and come up with recommendations for the second report. So I don't know, hopefully that falls in line with what we're thinking as a whole group, but.
Yeah, tell me the date in March that it's due. Is it the middle of March or the end of March that the first report is due?
Ms. Evans, I'm pretty sure it's March 1st. I can actually go
Okay.
look at the statute right now and get an answer to you in like a minute.
Okay.
all right. So I think, I think at least we've identified kind of the main areas. I think we've at least established a structure for our next 2 meetings, which I think is helpful. And maybe even after that, the second meeting, the one on the January 24th, where we'd be asking someone from DHS to present, I guess, depending on how long that presentation is, we can potentially, once that's done, just sort of discuss and fine tune our points. And so then we can potentially even have an agenda already for the meeting after that. And we'll just have to see time wise, but we'll be optimistic.
And Madam Chair, Ms. Evans, it is March 1st.
Okay. Yeah, this wasn't enough time.
Yeah, is there anything else? I think we've got items on the calendar, we've got items to discuss, we've got a plan for the next at least 2 meetings. Is there anything else that anybody can think about right now?
The only other thing that I would say about topics, and I'm not as familiar with, although I ended up doing it, I'm not as familiar with this process, is about appeals. Do we want to touch on that at all, this group?
We definitely can. I know it of course depends And of course, the other piece with appeals, the number one piece is, of course, what that reviewing court and their standard of review. And so I think that that's an important piece, but we can definitely, I think, touch on that, especially as we're looking. To me, that kind of fits a little bit with the expungements of if you're really not having success with DHS, what are your other options?
Okay.
If that's sort of a way to look at it.
Yeah, and I'm hoping that when we get someone from DHS in to talk about their discretion throughout the reconsideration process, that would also include someone to walk us through what it looks like when you challenge like a preponderance of the evidence determination to an ALJ or a DHS judge.
Yeah.
Because that's another place where, like, I don't know, does it make sense that the rules of evidence don't apply at those hearings? When it's functionally a fact-finding hearing on whether or not someone committed a crime.
Yeah. The other part that's really hard for me is like, anytime they do something happens, it seems like when it impacts stuff in a negative way for people who are trying to get their stuff back together and get back to work, they always do it retroactively. And then anytime that it impacts people where they can get back to work, that it's from the date of it, right? And so it seems like that's what happened to Dwan, right? They did it retroactively, and so it impacted his schooling. So if that's something that we could maybe address, that.
Well, and I think that that's an important piece, and I don't remember when it did come up, but one important piece to look at will be whether any changes that are made, are they retroactive? And that's, of course, an important thing that, for example, the courts will have to look at. And I typically would prefer to have that as a clear answer than to leave anybody guessing.
Yep.
Yeah, I appreciate that too. No, I was just thinking like, like more far as, I was thinking that I probably would have been grandfathered in, maybe, like with thinking like, so yeah, that piece is very important to me. But the most important piece is like, for the others to come, because I'm set up pretty good. God got a plan for me. Things are going to work out for me, but people are coming after me, So yeah, that's basically why I'm here, so, but whatever happens. God got me though. I mean, I'm not stressing about it.
No, and so I definitely did at least make a note of that, and so that we can, I guess, make sure we'll try to also come back to that too. Perfect. If there's anything else before we adjourn?
Thanks for leading the meeting.
Yeah, so if there's nothing else, we'll adjourn. And I don't remember, I think, Mr. Vogel, if there's something you have to do with that?
No, Madam Chair, you can just declare the meeting adjourned.
All right, so then we are adjourned, and we will see everybody after the holidays. Have a happy holidays.